I don't have any immediate plans. I haven't had the time to think about it. We've had a long, hard term at the court, and I centered upon this particular action and left the future to itself for a little while.
Warren suffered 3 heart attacks in 1974. On July 2nd, he was admitted to Georgetown University Hospital. A week later, Pat Patterson came to visit.
It was the best visit that I've ever had with Earl Warren. And the whole time he was governor, I said we had good visits and sat and talked. But tears came in our eyes because he said, we've had a lot of good discussions. He told me this on his bed. He says, all the problems, all the legal problems, all the legislative problems. And he said, it was a good life, wasn't it? We were the last one to visit.
Chief Justice Warren, history still debates your name. Looking back now, how do you explain a court that stirred the nation's soul? That weapon art that changed the role? No, I didn't chase legacy or fame. I listened when the questions came. Not marble halls or powers call, but human voices, one and all. They asked about the court's decree, but I remember every plea. A child at school, a man alone, a woman guarding her own home. Each case a name, each name a face, each moment time refused to erase. I ruled with law, but heard the cry of lives that asked the reason why. A quiet revolution, case by case. The Constitution stretching, holding space, not tearing it down, not starting anew, just making the promise honest and true. Yeah. So Chief Justice, was the cost too high? The anger, the noise, the battle cry. Ask the ones who brought the cases, hear their voices, see their faces.
He was called to Washington by President Eisenhower to become Chief Justice of the United States. And as Chief Justice, Earl Warren brought off so many nearly unanimous decisions on the most controversial issues in American life. You didn't come out of the judiciary from youth up.
No.
You were in the political world.
Yes.
You were the governor of California.
Yes.
Even though it was a bipartisan nomination, both the Democrats and the Republicans wanted you there.
Well, they did that once, but only once.
And then you were part of the national ticket with Tom Dewey running for the vice presidency, along with him as president.
Governor Warren, it's a pleasure to welcome you back on the Chronoscope program. Since you were last here, a lot of things have happened in the Republican Party. Some things have also happened in the Democratic Party, and we'd like to get your opinion on them, sir.
I believe that we cannot win just by pointing out the mistakes of the Democrats. You see, we haven't been in power for 20 years, and the people of America are going to want to know what we propose to do, and I believe that we ought to meet every problem of American life head on.
Defeat is but a lesson learned, a chance for growth, a page turn. The call to serve still loud and clear, a future path I hold dear. Dreams of the White House were in our sight.
from that political world, with all of its turbulence, you move into the Supreme Court as the Chief Justice and divest yourself completely, not only in actuality, but in mode of thinking, of any political involvement.
Well, I think that it is conditions in the Supreme Court are far more serene than the public has an idea of, because we read very often in the press about the great controversy that's going on in the court.
Or so I thought, where battles for freedom must be fought. Justice demands a steady hand to shape the law, to heal this land. Ooh.
The Warren Court walked into America's classrooms and asked a question the country had avoided for generations. Who gets to belong? In Brown, segregation fell. In Engel and Tinker, students learned freedom could sound like silence or protest. In Williams versus Lee, Native nations were reminded they were still nations. And in Baker and Reynolds, the court declared that every vote should carry equal weight. The Constitution was no longer whispering to the powerful, it was beginning to speak to everybody.
When I came to the Supreme Court, it was altogether different. I never saw an individual who was involved in any litigation. We'd never see a litigant in the court. All we know is that printed record that we get of the testimony in the trial, the printed briefs of counsel, and maybe a half-hour argument on each side at the podium.
Separate educational facilities are
inherently
unequal. Chief Justice Earl Warren.
Oliver Brown and others versus the Board of Education of Topeka, Shawnee County, Kansas.
I have heard the arguments, felt the pain. Whoa.
seen the faces of children, dreams in vain.
Whoa.
Our nation stands at a crossroads now.
To uphold justice, we must bow. Separate is never equal. Truth so plain.
Through chains of injustice, we must unchain.
We must unchain.
Together we rise, together we stand.
Together we stand.
For equality's light to shine across this land.
It is no part of business of government to compose official prayers. Justice Hugo Blood.
Stephen I. Engel et al. Petitioners versus William J. Vitale, Jr. et al.
Faith at home where it belongs, in family prayers and sacred songs, but school's a place for minds to roam, a neutral ground, a second home. Freedom to believe, to choose our way, to honor faith or in silence stay in this land of the free, where all are heard, no prayer imposed, no silence in word.
He can hardly be argued that either student or teacher shed their constitutional rights to freedom of speech or expression at the schoolhouse gates. Justice A. Wallace.
John F. Tinker and Mary Beth Tinker, minors, etc. et al. Petitioners versus Des Moines Independent Community School District et al.
The right to free speech flows through our youth. We must protect it, let them speak the truth.
We may be young, but our hearts are wise.
We see the world through open eyes. A simple band of protest song. We know what's right, we know what's wrong.
I remember the first time we discussed how long we thought it would take. I remember someone suggested, I can't remember who it was, wouldn't it be wonderful if on the centennial of the 14th Amendment that it would be a reality all over this country. And I've always remembered that and thought about it many times. It didn't become a reality by then, but still much more has been accomplished than most people realize. New York Times Company petitioner versus L.B. Sullivan.
Extra, extra, read it loud. Voices rising from the crowd. Ink and conscience, black and white. Printed truth in morning light. Full page call on March the 29th. 1960, the struggle in print. Hear their rising voices cry. From southern streets where children tried to claim a promise long denied. While freedom riders testified, they sang for Dr. King's defense. For jailed protesters paying rent in. They're rising voices. They're rising voices. They're rising voices.
Coming from an immigrant background and having parents that they don't understand the educational system, just having fundamental access to that education made me who I am today. If not, if these cases were implemented, immigrants, minorities, we would have been shut out of society without these fundamental rights.
In my mind, the most important case that we have had in all those years was the case of Baker versus Carr, which is what we might call the parent case of the one-man, one-vote doctrine.
In the cities we grow, in the towns we thrive, yet our voices fade, barely alive. Votes that count less, power misplaced. It's time to bring fairness back to the space. One person, one vote, the right to claim. Every citizen equal, every voice the same. From mountain towns to city streets, democracy's heartbeat, where freedom meets.
And as a result of that, we had the cases of Reynolds versus Sims.
Down in Alabama, the story's the same. Rural lines are drawn, and they play in the game. The cities are growing, the people demand, but they're silenced by the power of a line in the sand. Lines in the sand, holding us back, twisting the map to cover their tracks. Oh, we're standing up, we're breaking through. These lines can't define what we're gonna do. The power's with the people, it's time to stand. We'll redraw the line, no more lines in the sand.
I believe that if we had had that decision shortly after the 14th Amendment was adopted, that most of these problems that are confronting us today, particularly the racial problems, would have been solved by the political process.
I'm 25% American Indian. A lot of trips to go see our heritage growing up and be able to witness the everyday lives that they lived. And what really shocked me the most was just how long it took them just to get water every day. And we realized how hard the upbringing was for American Indians to survive back then.
All
Williams and Lorena Williams, petitioners versus Hugh Lee.
Through the mountains, through the plains, our sovereignty forever remains. No foreign court will decide our fate. This is our nation, we legislate. This is our nation, we legislate. Our land, our law, it's in our hands. They can't take what they don't understand. A sovereign people will take a stand to show the world this is our land.
You can't explain anything you did. You can't temper the thing in any way. You just have to accept it without any answer of any kind. And that's one reason why the courts are traduced so much in this country, because they can be used as a whipping boy, don't you see? They have no way of talking back, where a man who's in politics can fight just as hard as he wants to do it.
He sits in marble, far from the night, while cops face corners where wrong feels right. I don't question justice, I question control. When judges decide but never patrol, let him dream of fairness, let him speak slow, let him write opinions the streets won't know. Every revolution invites a reply, and water calls, they'll answer my cry. Courts don't win elections. I do.
Well, I would think they were terrific. They didn't complain, and nor have they ever complained since about it. But I know what the problems of some of them were. For instance, I think Justice Black was not welcomed in Alabama for a good many years after the Brown decision.
I swore an oath to do what's right, to fight for freedom, to shed new light. But in this storm with hatred strong, how do we hold on? How do we belong? Under fire, the flames rise high, voices shout, banners fly, standing firm but feeling small. Will justice answer?
As the streets grew louder, the Warren court turned toward the police station, the jail cell, the courtroom. In Mapp, the government could no longer benefit from illegal searches. In Miranda, silence became a right. Duncan, Brady, and Wade, and Gideon demanded fairness before freedom could be taken away. But in Terry, the court also widened police power in the name of public safety. And as fear spread across America, Richard Nixon promised law and order, while the nation argued over whose safety mattered most.
Dolly Mapp had the presence of mind when the police arrived and wanted to search her home to get on the phone and talk to her attorney. She told them, "No, you're not going to search my home without a warrant."
Etc. Appellant versus Ohio.
Without a warrant, you can't come in without a warrant. You don't begin. The Fourth Amendment draws that line. This home, this space is mine. And if the search is born from wrong, the evidence won't sing your song. It falls away, it won't remain. No lawless game will stake its claim.
We need not hold that all evidence is fruit of the poisonous tree, but this evidence, derived from an unlawful entry, is inadmissible. Justice Stewart.
Long Son and James Watt Toy, petitioners versus United States.
They came to my door, no knock, no care. Enter my world like a storm in the air. Took what they wanted, no warrant in hand. But justice demands we make a stand. Fruit of the tree, tainted and foul. Evidence taken with
John W. Terry et al., Petitioners versus Ohio.
Reasonable suspicion, a double-edged blade, with freedom and safety dance, both afraid. Who decides, who draws the line? When does justice overstep, cross over the line?
The Warren Court was just as politically charged as things are now. The importance of that court was not so much the decisions they made, but the rights they stood up.
Ernest Miranda, Petitioner versus Arizona.
You have the right to remain silent. Anything you say can be used, so be wise and defiant. You have the right to an attorney if you can't afford one. Don't you fear? These are the rights, now know them well. For in this room, your freedom's held.
The prosecution may not use statements stemming from custodial interrogation unless it demonstrates the use of procedural safeguards effective to secure the privilege against self-incrimination. Chief Justice Earl Warren.
The judge says wait, the lawyer says pause, but I hear footsteps breaking laws. I hear mothers locking doors. I hear silence begging for more.
The big signboards that we'd see along the highway saying "Impeach Earl Warren," and I became used to that very quickly, and it didn't bother me.
That must have been pretty hard on Mrs. Warren.
Well, it really was a lot harder on her than it was on me.
Our home was safe, our world was bright, but now we live in constant fright. Now every day we live in fear. This weight is more than we can bear. Impeach Earl Warren, they call, they shout. Justice way down, voices of doubt. A fight for rights, but the cost is steep. Promises made, but wounds run deep.
A dark page in the annals of America has been written to the crack of an assassin's bullet. A nation mourns, the world grieves. The man who became 35th president less than 3 years ago is dead.
No investigation could have been more painstaking than that carried out by this commission. Every resource of criminology was called into play: ballistics tests, analysis of the guns themselves, handwriting analysis, the blanket in which the rifle was wrapped, the photographs and the documents linking Oswald to the crime. And Earl Warren was not too dignified to race down the stairs at the depository building, matching his time against Oswald's. In the end, we find confronting each other the liar, the misfit, the defector on the one hand, and 7 distinguished Americans on the other. For the Warren Commission could not give Lee Harvey Oswald his day in court in the protection of our laws.
Clarence Earl Gideon, Petitioner versus H.G. Cochran, Director, Division of Corrections.
I wrote my plea, I told my tale, how fairness failed, how freedom's frail. I may be poor, I may be small, but the right to a lawyer belongs to us all. Justice is not just for the wealthy or those with education. It's what our nation is built on. Its very foundation. And every person, rich or poor, deserves a fair trial. Evermore.
United States Petitioner versus Billy Joe Wade.
I stand in this line, shadows all around. No lawyer here, no friend I found. Words that make me say the fear I feel. Where's my defender? Where's my shield?
Trial by jury is fundamental to the American scheme of justice. Justice White.
Gary Duncan, appellant,
versus Louisiana.
Without a trial by jury of peers, the scales of justice tip way too near in favor of the rich and potent ones. But how is that fair to everyone? We have to ensure every voice is heard, that a jury hears all defendants' words. Every right upheld, everyone judged fair. 6th Amendment says.
It's just unbelievable to read that and understand that. And you could be found guilty by one corrupt judge and then be sentenced to life in prison or never get to see your family again. I went to Angola, which is one of the biggest prisons in Louisiana. I witnessed firsthand people who are in incarceration for life.
John L. Brady, petitioner versus Maryland.
Evidence hidden, kept away. How can truth see the light of day? I stand accused, yet facts concealed. Without the truth, my fate is sealed. What good is justice cold and blind when fairness is so hard to find? The whole truth, nothing less.
Then the Warren Court entered America's most private spaces, the telephone call, the marriage bed, the human body. In Katz, privacy became more than a place, it became a principle. In Griswold, married women gained the right to make intimate decisions without government control. And in Loving, the court declared that love itself could not be segregated by race. But while freedom expanded, backlash rose beside it. And as Nixon took the oath of office from the Chief Justice Earl Warren, America stood divided over what liberty was truly meant to mean.
The Fourth Amendment protects people, not places. Justice Potter Stewart.
Charles Katz, petitioner versus United States.
How we see privacy must evolve. It's not an easy problem to solve. The fourth protects people, not just the place, not just their things. Let's not erase all our privacy when nature's free. Lies we cross, racks we bend. Where does privacy start? Where does it end? The conversation, a quiet space in a world of eyes. We leave no trace.
Marriage is one of the basic civil rights of man, fundamental to our very existence and survival. Chief Justice Earl Warren.
Richard Perry Loving et al. Appellants versus Virginia.
We built a home, we built a life. Husband and husband, wife and wife.
But courts and laws tried to tear apart
what God has joined, what's in our hearts.
We dream of a world where love is free, where hearts aren't judged by what they see, where hand in hand we walk unafraid. A future bright, a promise made.
Love knows no bounds, no color, no creed. It's a force that binds a human need. Hearts entwined, we stand so tall.
Love is love for one and all. My mom was a white woman and my dad was Haitian, and they got married. And I know that if loving hadn't existed, that wouldn't have happened, especially in the South. And
I'm happy that they were able to do that for that period of time. And it's really important to know your history. If you don't know your history and you don't know the mistakes of the past, you're doomed to create them again. It's important, even if your history is not pretty or kind, that we know it.
Number 496, Estelle T. Griswold et al., appellants versus Connecticut.
Wasn't just pills, it was dignity and hope. A lifeline for women who struggled to cope. With each consultation, they found their voice. We gave them knowledge, we gave them a choice. The law said no, but we said why? Why should their health be denied on a lie? A right to privacy, to love, to plan. This isn't radical, it's human, it's grand. For every woman who dreams to decide, for the power of choice we won't let hide. To plan her future, her body, her life. We stood for freedom in this bitter strife.
The marital relationship lies within a zone of privacy created by several fundamental constitutional guarantees. Justice William O. Douglas.
The criticism that comes from the public, from the media, from the people who are disenchanted or discontented or in opposition to you, sometimes taking pretty abusive form, you wouldn't say that the political world was an easier world for you to adjust to than the judicial world because of the criticism that came.
Well, I think I would, because I think I would, because in politics, a man can stand up and defend himself and explain things so people can understand, and that the news media will normally carry, and he releases the tension that he has by so doing. But when you're on the Supreme Court, you can't do that.
If I find a man, whether he's a Democrat or Republican, or known as a liberal or conservative, who recognizes that it is the role of the court to interpret the law and to leave to the Congress that of writing the law, that's the kind of a man that I want. I do not want the court. I think some of our judges, and I respect these men as men, but some of our judges have gone too far in assuming unto themselves a mandate which is not theirs, and that is to put their social or economic ideas into their decision.
Rights are not popular by design. Neither is losing elections.
I don't serve comfort. I don't serve fear. I serve a constitution meant to endear. When history asks who stood the test, it won't ask who shouted loudest.
History remembers who took command, who drew the line, who made the stand. Let the court decide what it can. The rest of the country answers to one man.
City don't sleep, windows crack, sirens talk back, feet move fast. You say wait, I hear run. You say right, I see God.
Power knocks.
No name,
no warrant,
no shame.
Law means limits,
not control.
Brakes on force, lines on roll, lines get crossed when no one's checked. Fear is real,
so much respect. Who decides? Who draws lines? Who stands firm when power's loud and rights go quiet? Badge on chest, split second call. Street don't pause, courtly walls. History counts. Every choice, every silence, every voice. Justice, order, rights, control. Order, justice is not loud. It is not loud. It is lasting. Of that I am proud. Power doesn't wait, it's impatient. I won't hesitate.
And the more complex it becomes, the more people have to realize that only they can keep this republic. If the citizens of this country don't do it, there isn't anyone on earth who can keep it a republic. And throughout history, republics have gone down the drain because people have lost their interest in them. A republic is not an easy kind of government to keep because it depends upon every living soul in it. And it is because I believe the responsibility to keep it must be equated with the rights it bestows that I use the expression of Dr. Franklin to the effect, it's a republic if you can keep it.
Justice, written and true, we pass the torch from us to you. Freedom's fight is never done, but together we rise as one by one. Our work is not finished, there's still more to do. The Constitution's fate, it's up to you. It breathes and evolves, not all problems it solves. Promises made must be defended, no matter that some pretended to protect these rights for us all. Today we pledge to heed the call. The Constitution's revolution. We made the right, we did the work, we fought the fight. Constitution's revolution. We made the right, we did the work, we fought the fight. Do you see some? Be defended, no matter that they just pretended that these rights would apply to all. Today, will you heed the call? Today, will you heed the call? We ask that you heed the call.